Good morning, ladies and gentlemen, and I'm appreciative that it's afternoon for some people that are dialing in from other provinces. I'm going to give it about 2 more minutes before we formally start. We have 300 people registered for today, and about half of them are already online. So we'll just give 2 more minutes before we go into any admin instructions and introductions. Be right back. Well, once again, good morning to everyone in Alberta and points west. Good afternoon to anybody points east of Edmonton and Calgary. We're going to take a few minutes to introduce your sponsoring organizations and allow just a couple more minutes for folks to register. We have over 300 registered for today, and some of them are still logging on. My name is Paul Conway. I'm the Executive Director of the ADR Institute of Alberta. And it's my pleasure to co-host this webinar with you this morning. A little bit about ADRIA. We have about 700 members, and we're the professional association for mediators and arbitrators and other ADR practitioners in the province of Alberta. We're part of a federation of ADR institutes across the country and led by ADR Canada out of Toronto. Like everyone else, we've been impacted by the COVID situation. We're certainly looking forward to relaunching our in-person classes this fall. But we've actually really enjoyed the opportunity to move some of our programs online and to host webinars such as this. ADRIA is in fact the only affiliate that offers a comprehensive suite of training opportunities. And now that we're increasingly moving online, those same opportunities are available to folks that can dial in from other provinces and quite frankly from around the world. We have an in-person class, for example, coming up in conflict coaching, but we've gone online with high conflict mediation and ADR communications, and you can find details of that by visiting the ADRalberta.com website. Take a few minutes to visit the website, register for a free newsletter if you're not a member, kick the tires, read our annual report. I encourage you to take a good look at what we have to offer and consider staying engaged. On that particular note, our next online luncheon will be July 14th at 11:30 Mountain Time. It's a bit more craft oriented. It'll be entitled Getting Ready for a Virtual Hearing, and the speakers will be Carol Zukowski and Adrian Wright. This webinar will be of obvious interest for those that are involved in the delivery of administrative justice, tribunals, arbitration, and even for online mediation. So on that note of administrative justice, allow me to introduce our other sponsoring organization, the Foundation of Administrative Justice, and they have 2 co-executors, Karen Popoff, who will speak to us now, and Sherilyn Danis. Karen, would you like to say a few words? You'll have to unmute yourself, Karen.
Thank you, Paul. Welcome from the Foundation of Administrative Justice, FOAJ as we like to call it. Thank you for joining us today in this effort with ADRIA. I won't take too much of your time, but would like to tell you a little bit about the Foundation of Administrative Justice. It's a training organization that assists decision makers who sit on tribunals. We are the only one that has a certificate in tribunal administrative justice. This certificate assists tribunals and participants to evaluate and support competencies in administrative justice roles. Our courses include, but not limited to, interpreting legislation, decision-making, decision writing, effective hearings, and principles of administrative justice. One course that we have that I'd like to tell you about today is the cultural competence, cultural intelligence. It is the capability to function effectively across a variety of cultural contexts in a respectful manner, ensuring equity and justice. This course explores a number of models, including the dimensions of diversity, cultural competence, and high and low context cultures over 2 mornings. It is designed to explore unconscious bias, how it plays out in our community, the impact on fairness and justice, and how to explore and challenge our own unconscious bias. We're hosting this course on July 29th and 30th from 9:30 to 1 o'clock each day. FOAJ is still here for you, providing training through live streaming and e-learning options. I invite you to visit our website at foaj.ca. Thank you. Back to you, Paul.
Thanks, Karen. I appreciate that. So a couple of websites there for you to check out, and we appreciate your interest today. We're getting close to some of the numbers that we're looking for. So just a few admin instructions. We would encourage you to use the chat function if you have any questions that you'd like put to Ry or to any of us for that matter. If for any reason the chat function is not working, you can use the Q&A, but we're gonna give preference to the chat function. I will try to monitor that throughout the session. And please pose your questions as the session proceeds. I will either interject with a question, or I'll try to group them together for a Q&A at the end, an informal Q&A. And Ry is willing to stay on as long as possible. We are going to record today's session. It is likely to be posted online for viewing and sharing later. And as I said, there will be time at the end for Q&A. I'll be introducing Ry shortly, but I just want to start by acknowledging, and I think that really just by our presence here today, we are demonstrating. We're demonstrating that we do want to do more than just, we do want to do more in terms of reconciliation, and we want to learn more about reconciliation and the Indigenous communities that are an important part of Canada's fabric. So let us begin by first acknowledging that for many thousands of years, Indigenous people have walked these lands, weaving their identity and their spirituality intimately with the land. We acknowledge with respect that we live, work, and play on lands often delineated by treaty or otherwise occupied by settlers. Let us keep mindful of the covenants that we have made and many often broken with our Indigenous peoples. And may we continuously live with respect on this land, moving into reconciliation with all who live and work here in Canada. I also want to note that this weekend marks National Indigenous Peoples Day on Sunday, June 21st. The notice is perhaps short, but the University of Calgary is sponsoring some exceptional speakers tomorrow between 2 and 3 p.m. Mountain Time, including Chief Reg Crowchild, who has spoken at some of our ADR gatherings previously. So I encourage you to honor that day in a manner of your own fashion, and also to, if you're interested in the University of Calgary session tomorrow, registration is required, and I believe Sandra is sharing the website with you. I also want to note that the National Center for Truth and Reconciliation is not a charity, and therefore, and these luncheons are free. But if you do wish to acknowledge your appreciation for any of Ry's words today, or I do encourage you to find an appropriate charity of your choice and make a small donation. Ry did mention that they've worked closely in the past with the Boyle Street Center here in Edmonton, so that is certainly one option. And if you visit their website, you will find a donate online button at the bottom of their pages. So small or large, and certainly no requirement to make any sort of a donation. But if you wish to express your appreciation for Ry's time with us today, I encourage you to take up one of those options. So allow me to introduce our speaker. Ry Moran is the first director of the National Centre for Truth and Reconciliation, established in Winnipeg, Manitoba at the conclusion of the Truth and Reconciliation process. His job is to guide the creation of an enduring national treasure, a dynamic archive built to store the memories and recollections of those that were impacted by the residential school process or other aspects of treaty negotiations and Indigenous interrelationships here in Canada. Prior to that, Ry worked directly with the Truth and Reconciliation Commission of Canada, the TRC, and many of you had an involvement in that. And on their behalf, he facilitated the gathering of nearly 7,000 video and audio recorded statements. And you can certainly read more about Ry's background and contributions to the TRC process and his ongoing work with the National Centre on our website or by visiting their website. Ry is he has a previous background in film and video work with the Indigenous communities of Canada. And he's a role model and an Aboriginal music recipient of a Canadian Aboriginal Music Award, which I'd love to hear more about, Ry. He's a Métis himself, and it is with great pride that I turn the mic over to Ry for our presentation today. Thank you, Ry.
Great. Well, good morning, good afternoon, everyone. Paul, thank you very much for that wonderful introduction and for offering this opportunity for me to share a little bit of our journey of truth and reconciliation with you all. It's very much an honor and a privilege to have the opportunity to speak with you. And I really sincerely hope that you're going to take a lot away from this in both the remarks that I bring and the question and answer period that we have at the end. I am speaking to you from Treaty 1 territory, homeland of the Métis, land where my Métis family is from. I'm living about maybe 15 kilometers away from some of my family's river lots, and I relocated here from Victoria, BC, actually, to join the Truth and Reconciliation Commission about 11 years ago, and have been absolutely blessed with an incredible and life-changing set of experiences, teachings, learnings through this journey. My traditional name is Wapikinyu, which is White Eagle. I'm of the Turtle Clan, and like Paul said, I'm Métis from here in Red River. So when we talk about June is actually a really interesting month for us as a country. And this particular June is in some ways particularly auspicious because we're going through a series of landmark passages of time in this month. And what are those? Well, earlier this month, June 2nd and 3rd, we marked 5 years since the Truth and Reconciliation Commission's calls to action were released. That same period also marks a full year since the calls for justice of the missing and murdered Indigenous women and girls inquiry were released. Right now, in this week, June 16th through 19th, marks 10 years since we held the first Truth and Reconciliation Commission national event here in Winnipeg, Manitoba, where we lit the first of 7 sacred fires, the first of the fires being lit on the teaching and in the theme of respect, because we believed at that point and continue to believe right up to this day and continue to help people understand that reconciliation means many things, but it starts with respect, and it's all about the establishment and maintenance of mutually respectful relationships. And that idea of reconciliation being the establishment and maintenance of mutually respectful relationships is actually an extraordinarily powerful window into the work that we have been asked to do as a country. because it doesn't say to reestablish respectful relationships. It says to establish. That says that we have never enjoyed a respectful relationship with Indigenous peoples in this country. And certainly when we look to our past and to the extensive histories that we documented at the Truth and Reconciliation Commission, we're all too painfully reminded of just how horrific our history, our shared history has been together as Indigenous and non-Indigenous peoples. It is a history that is mired with violence, oppression, genocide, war through legislation and statute, and shortened lives of Indigenous peoples. And this has combined to result in an under-realization of the aspirations of our country. It has resulted in an under-realization of our full potential as humanity. And it has certainly resulted in very difficult situations for many. Conversely, however, it has also been a period of time wherein Indigenous peoples themselves have demonstrated great resilience and fortitude and determination to overcome this oppression and genocide. We owe such a debt of gratitude to all of those elders and knowledge keepers and young people and old people and keepers of the fire that kept the languages and the cultures and the traditions and the knowledges alive, so that we collectively as a country could benefit from that now, that we can learn from one another still, that information can be passed on. Because we have to remember that Canada's efforts of cultural genocide were intended to eradicate all of that. Were intended to destroy all of that incredible richness that emanates from this land, that is born out of this land and has so much to teach us about what it means to live respectfully in this land. So the establishment and maintenance of mutually respectful relationships calls upon us to do the hard work necessary today to build that healthier relationship, so that our futures collectively are brighter together, so that we resolve this inherent conflict that's so present at the very center of the notion of Canada, that sees Indigenous futures as somehow being different than Canadian futures. Wherein if Canada as a country fully were to protect and espouse Indigenous aspirations, that somehow Canada itself would be losing out on something. And that's the entire conversation that we have to turn on its head. We have to see that the future that we're collectively aiming to build through this process of truth and reconciliation, this process of healing, is one about building a richer, stronger, better country for all Canadians. Turning to the questions, the broad questions of June's and truth and reconciliation, the other important landmark that is marked by June is the historic apology made by not just the Prime Minister, but the leaders of all federal parties, which occurred on June 11th, 11 years ago. That apology stated two very important things. One, it apologized for the residential school system as a whole and said that that system was wrong, period. And that admission that the residential school system was wrong in both execution and intent must always be remembered, because there are people that today continue to seek out this unfortunately misguided notion that, you know, it wasn't that bad and, you know, there were some positive experiences too. But we have to remember the overall concept and underpinnings of the residential school were fundamentally misguided. They were fundamentally based on inherently oppressive, assimilative goals and objectives. So yes, while there were, you know, sparse scatterings of light and good experiences within, this was an inherently and predominantly bad system for Indigenous peoples and bad for the country as a whole. The second part in the apology reflects the work that we still have to do today. And what the Prime Minister acknowledged was that the attitudes and ideals that gave rise to the residential schools have no place in Canadian society. And what we have to recognize as Canadians is that those attitudes and ideals that gave rise to the residential schools, that legitimated their creation and their maintenance and their existence for over 150 years in this country, are still very present in our society today. And this conversation that we've been having recently and ever more vocally around systemic racism and discrimination is actually very much at the heart of the work that we need to do and the terrible things that we need to unlearn as a society, the ways that we've been taught to see one another that are based on inherently racist and oppressive ideas. And certainly the conversation around systemic racism that has been occurring, especially in the last couple of weeks in this country, is absolutely the right conversation that we need to be having. And I must be very clear in stating that there is no institution in this country that is immune from systemic racism, because this country is founded on and still maintains a system of systemic discrimination, systemic racism against Indigenous peoples. So be that our systems of governance, be it our systems of bureaucracy, be it our universities, be it our systems of justice, be it our policing systems, systemic racism is a problem across all of these organizations, institutions. And what tells us that? Well, we have been on this journey of reconciliation now, actually for a very long period of time in this country. Starting in the 1950s, when Canada began to really start to think through what its obligations were as a state in regards to human rights, following the UN Convention on Human Rights, Canada began to take a much harder look at itself in the mirror and began to realize that some of the activities that were happening in this country all of a sudden were no longer as defensible as they were perhaps before World War II, and perhaps when humanity was exposed yet again to the full horrors of what humanity can do to each other, what we can do to each other's humankind when human rights aren't upheld and protected. In that 1950s period, things were still very, very bad in this country, but we began to take a series of slow steps to unwinding a great deal of the damage that was done. And of course, by 1982, we saw Indigenous rights, Aboriginal rights enshrined within the Canadian Constitution, which then sparked a whole surge of Indigenous lawmaking and rights definition. Now, we have a lot of work still to do in that field. But that represented a fundamental shift and growth in the increase of power that Indigenous peoples were able to exert within Canadian society. So that by 1988, when J.J. Harper was shot and killed by a police officer here on the streets of Winnipeg, an Aboriginal justice inquiry was struck to investigate systemic racism and policing and the unnecessary death of Indigenous peoples that had been plaguing this country for far too long. Of course, Senator Murray Sinclair was one of the commissioners of that justice inquiry. And what did they reveal at that point? Well, that systemic racism and discrimination was absolutely present within our system of justice and needed to be addressed. And they issued a huge volume of recommendations, some of which were implemented, many of which, of course, were not. And we fast forward a few short years after AGI, and what happens again? Well, in Quebec, we see, again, armed conflict between police and Indigenous peoples, again, with people losing their lives at the Oka crisis. And what do we do then? We again go back and say, my word, let's ensure that this never happens again. We have to understand how these patterns are recreating themselves. So we undertook a Royal Commission on Aboriginal Peoples and issued over 430 recommendations in the creation of that report, again, which discussed the fundamental changes and reforms that we needed to undertake in society so that these patterns would not repeat themselves. Fast forward later, we see the Stonechild inquest after Indigenous peoples are found to be killed by police officers in Saskatoon, being dropped off on the Starlight tours. We see Ipperwash happening in Ontario, wherein again, yet another Indigenous person dies and is killed at the hands of police. We see the Truth and Reconciliation Commission issue its reports largely in response to the profound injustices and the unnecessary death, again, of Indigenous peoples in this country and the demand for change. Missing and Murdered Indigenous Women, it's an inquiry, again, looks at these patterns of systemic racism and the failures to uphold justice for Indigenous peoples in this country. More recently, again, more reports out of Thunder Bay, again, authored by Senator Sinclair and Valdor. The common denominator in all of this is that our systems of justice are not just for Indigenous peoples, and that is where alternate healing processes, alternate reconciliation processes have been sought out. And we've attempted to use these as a way to help our country move through this process of transitional justice. Now, the concept of transitional justice is very important, and we should never lose sight of the reason why we had a Truth and Reconciliation Commission in the first place, why we chose that mechanism, that internationally recognized mechanism, to try to help this country. Transitional justice mechanisms, such as Truth and Reconciliation Commissions, are used to move a country as a whole from a state of inherent conflict to a state of peace and good relation. Now, this is particularly challenging in our country because we've never enjoyed a peaceful relationship. Despite the appearances of Canada being a peaceful country, it has not been peaceful at all for Indigenous peoples. In fact, Canada has become much more, this land has become much more dangerous, violent, and oppressive for Indigenous peoples since colonization occurred. So as a nation, we chose to use a process that has now been employed by over 60, close to 70 nations across the world to try to move it from this inherent state of inherent human rights violation and inherent conflict to a state now of peace. And that's why we chose to implement and utilize this Truth and Reconciliation Commission, is to move us in a good way towards better relationship, towards right relationship. Now, there's a couple things that I want to talk about specifically in regards to the process of justice that happened within the TRC. And I do want to talk about the statement gathering process in particular. Now, this is something that, of course, sits near and dear to my heart because I was the director of statement gathering. And for certain, I will never say for a second that we did everything perfectly or that we got it all right. But I think we did get a couple things right. And I want to share a couple of those things with you. One, what we did do at the TRC, and what I think one of the real strengths was at the TRC, was that it was an Indigenous process for Indigenous peoples, wherein non-Indigenous peoples were welcomed into an Indigenous space. Okay, and I think that's a really important concept. It was Indigenous-led, Indigenous worldview and thinking, spirituality and ceremony infused absolutely everything that we did. And then we made a very conscious and deliberate effort to ensure that we were hiring Indigenous peoples that had strong cultural safety, strong cultural acumen, and non-Indigenous peoples that demonstrated that they could operate in safe ways with Indigenous peoples. That was not an area that we could compromise on. And that was something that was very, very important to the TRC. And I think the selection of the commissioners, you know, Senator Sinclair, Wilton Littlechild, Marie Wilson, were all very wise selections by this country because certainly they brought a lot of that Indigenous knowledge and thinking into the activities that we rolled out. When it comes to the statement gathering process, the other thing that really was central in that was the recognition and the fundamental trauma-informed recognition that there's only one path to healing when you're a victim of trauma, and especially early childhood trauma, and that is through talking about it. You cannot heal unless you begin to dialogue and talk about your traumas that you have experienced. And especially when it comes to early childhood trauma, the painful part of this is that you kind of have to go back, from what I've been taught through working with the health support workers, you kind of have to go back and you have to kind of sit with that child that was injured and visit with that child that is still within you and spend some time there and try to set that right in the past and try to let go of all that guilt and that shame and all of those other terrible emotions that come along as the byproduct of the abuse, and let go of some of that guilt and shame and confusion, and realize that instead of you having done something wrong, that a great wrong was done to you by the person that took away your inherent right to be safe, to be secure, to be protected. So talking through collective pain and individual pain is recognized as being a pathway to healing. But we had to ask ourselves, how could we do that in a good way? And how could we do that in a way that would not create further harm or would not re-victimize people, where it would empower people to share what they wanted to share, but not force them to share what they didn't want to share. Because the concept of progressive disclosure has to be made central in a trauma-informed and a victim-centered approach when approaching work with people experiencing high levels of trauma, especially as it relates to colonial violence. This idea that you can't simply just disclose everything at once, that progressive disclosure is a process of thinking and revealing and unpacking and unbundling and discovering and breaking down a series of mental and emotional and spiritual and sometimes even physical barriers that are erected within oneself as a kind of a preventative mechanism of the body, an unhealthy preventative mechanism, but a preventative mechanism of the body to shield us from some of the worst things that we've all experienced or that some have experienced. So this concept of progressive disclosure was very important. And how did we address that at the TRC? Well, we always said that a person was free to talk to us as much as they wanted, whenever they wanted, and that they could share with us whatever they wanted when they were ready to share with us. So what we saw is we, in fact, saw people come back to many TRC gatherings a couple of times, 2, 3, 4 times, and share in different settings, in different circumstances. And I can remember being at a gathering in Toronto where one person, was sitting in the sharing circle and said, "Thank you for welcoming me back, because each time I talk about this and each time I hear the experiences of the people in the room around me, it gets a little bit easier. And I walk that little bit further on my own healing path." And that helped reassure us, I think, that what we were doing was contributing to healing. The other part of the process that we really tried to embed was agency. So giving people as much agency as possible as they went through the process of disclosure or sharing their experiences with the TRC. So how did we address that? Well, we recognized that there was no one-size-fits-all answer to everybody. And while we had to standardize things to a certain extent, and while we had to put protocols and procedures and policies in place, and while we had to, create a sort of repeating system just for administrative purposes and for management purposes, we really tried to provide participants and survivors with as much agency as possible. So that meant that coming in, especially to one of our major national events, is that people had a lot of choice that was presented to them, and they were allowed to pick and choose the pathway that felt best for them depending on where they were in their healing journey. Now, of course, it wasn't always perfect. We weren't always able to provide the perfect solution with to the individual, but I'll give you a couple examples. So some people really wanted to speak publicly. They were at a point in time in their healing path or in their healing journey that they said, I want the world to know what happened to me. I'm not ashamed of it. I need people to hear my story. So for them, we offered them the opportunity to speak in front of as many people as we could gather in the main room to the commissioners. And essentially at that point, what we did was we never appropriated their voice. We never took their voice as our own. What we did is we empowered their voice. We gave that person a microphone, an audience, and some really big loudspeakers so that they could say whatever they needed to say. For others, it was more of a process of disclosure in a sharing circle, and where there was other survivors present and you could hear and listen to one another in that sharing circle. And for others still who weren't ready to do the big public event, or perhaps who we couldn't accommodate on the big public side of things, then there was private statement gathering activities that occurred, wherein in a one-on-one setting, or actually on a two-on-one setting, where there was a health support worker and a statement gatherer in the room, the person was empowered and free to share whatever they wanted with us. And there was different levels of consent there, so they could choose to still offer a public statement or a private statement. And they could choose to have a video recorded or audio recorded. They had full and complete agency to stop and to start. They could get all the way to the end of their recording and ask that everything be deleted. And in a couple of situations, we even had people that didn't want anything recorded at all. They just wanted to tell somebody what had happened to them, just to help alleviate some of that burden and that weight of what they had been carrying through their life. So the last thing that I'll share in there too is, you know, because we tried to adopt as culturally informed an approach as possible, we infused ceremony through all of it. We did not ask many questions throughout the process. We believed generally that people were coming into the TRC knowing that they wanted to share something, and we let them share whatever they wanted to. We didn't let them. We sat there and gave people the space to share whatever they wanted to share with us. We also made a very deliberate and conscious effort to ensure that Indigenous languages were present throughout all of our work as well. And this is very important because, again, from a trauma-informed perspective, and what we had been told by many people working, especially with elders and elderly people, just generally as a society, that when you begin to reach older stages of life, that your first language ends up becoming dominant again, and your second language may become less dominant. So they see this apparently in old folks' homes and other places. So we wanted to respect that, especially given the long duration of history. Some of the statements that we gathered were from people well over 100 actually, and we spoke to many people in their 90s. And from both an affirmative perspective in recognizing the inherent legitimacy of Indigenous rights, as in an affirmative perspective from ensuring that we did everything we could to protect and preserve Indigenous languages, and to ensure that we were meeting people in a good way. We ensured that Indigenous language interpreters and simultaneous interpretation was present at all of our hearings and all of our national events, which wasn't easy, which certainly cost us more money, which required us to sometimes have as many as 7 or 8 language interpreters operating simultaneously. But it was the right thing to do, because residential schools were founded upon the notions of killing Indigenous languages. That was their primary purpose and intent, was to destroy and eliminate those Indigenous languages from Canadian society. So the other big element now, I want to transition a little bit, and the other major process of the Indian Residential School Settlement Agreement was the independent assessment process. And I do want to compare and contrast a little bit with that process to the TRC's process, and offer a few perspectives that have been shared on that process that I hope are going to be helpful for you as practitioners of alternate dispute resolution process in Canada. So Canada did try to embark on an ADR process before the settlement agreement was negotiated, because it was becoming abundantly clear that, one, survivors were winning their cases that were being brought in front of the courts, and were winning quite handily despite every single effort to quell and suppress those cases from occurring, being used by both the churches in Canada. But the increase of court cases did force Canada to begin to try to resolve some of these claims that were coming forward. And there were a variety of efforts, some very successful efforts and then some less successful efforts to develop effective ADR processes pre-IRSSA, pre-Indian Residential School Settlement Agreement. That said, the failures of those ADR processes related largely to the time that it took to move people through the process, the relatively low rates of compensation, some of the mistreatment experienced by residential school survivors, wherein they were kind of given take it or leave it type settlements. And this was largely recognized as being inappropriate and inadequate after significant study and reflection. There has been, since the outset of all of these justice mechanisms put into this country, sincere feeling that we are in a race against time to give survivors some justice before they passed away, essentially. Because each and every day we continue to lose survivors. And each and every day we have to remind ourselves that survivors are leaving this world with some feeling on whether or not justice has been rendered and served, and whether or not this country has truly made the shift necessary to ensure that no child anywhere has to endure what they suffered at the hands of Canada. So the combined effort to improve and streamline the ADR process resulted in both the common experience payment, which recognized the compensable harm, the tort, for having attended a residential school, and then the independent assessment process, which was the mechanism intended to compensate survivors for the serious sexual and physical abuse that occurred in the residential schools. Now, some of you may be well aware of the general numbers of participants through these processes, but about 80,000 survivors received the common experience payment. And at the outset, the estimate was that about 12 to 14,000 of those survivors would have successful claims for sexual or physical abuse within the residential schools. The actual number of claimants that went through the IAP process was far higher than that, though. It was threefold higher, and nearly 40,000 survivors went through the IAP process, and ultimately the vast majority of those had claims approved and compensation awarded for sexual and physical abuse. So the 50% statistic there of survivors indicates the depth and severity of the abuse that was present in the residential schools, and gives us a strong indication and strong insight into just how systemic and violent that system was. Now, the IAP process was intended to give survivors the benefit of the doubt. It was also a compromise wherein parties gave up the right of cross-examination for, a settlement. So, nobody was really going to jail as a result of the settlement agreement. People were parties, churches and government's liability was limited, and in exchange for a defined process wherein survivors would be financially compensated through this process. And it was meant to be less adversarial than a regular court process, which was seen as being kinder and gentler for residential school survivors. In many regards, that proved to be true. It has certainly been a kinder, gentler process than standard cross-examination. And we have certainly heard from many survivors that were involved in that early litigation period that preceded the settlement agreement, that went through the full brunt of cross-examination in court, and they said it was an absolutely brutal process, so much so that there were survivors along the way that committed suicide as a result of that. So the IAP process was certainly intended and largely succeeded in terms of being kinder and gentler, but there were a couple things that I think are worthwhile noting about the process that we've heard from survivors. So one, the process itself involved, it was much more legalistic than the TRC process. There was no need to have a lawyer to speak to the TRC, and actually there was no value in that whatsoever. People could show up at their own free will, participate at their own free will, at their own volition, and could say whatever they needed to say and leave. Whereas the IAP process, because there was kind of some evidentiary burden associated with it, and because there was a sincere concern about survivors receiving justice, that it was much more lawyerly and legal from the outset. So again, like most professions, there was a number of fantastic members of the legal profession that really did an outstanding job and really represented their clients well. There are sadly many examples of members of the legal profession that did an absolutely horrific job too, and saw it either as a cash cow or as the next big thing to make money off of. And at the worst of this process, survivors were literally mined as being yet another kind of extractive resource to generate money from, and were harmed along the way, were treated poorly, and actually victimized as a result of it. So there's some serious concerns that we all need to pay attention with in terms of how members of the legal community treated survivors through this process. And it's not painting everybody with the same brush. There's some fantastic examples, but conversely, there were some people that were really in it for the wrong reasons. And we need to be very cautious about that when we're dealing with either these mass compensation processes or healing processes. This cannot, very honestly, this cannot be a money first process. You're either committed to this work for the right reasons, or you shouldn't be involved in it, period. Survivors are not commodities to be extracted from. They are people that deserve help and support and a lot of respect and the full effort of this country to assist them in their quest for justice. And it's unfortunate that some were absolutely harmed by the process along the way. I think the other thing too is again, you had an unequal and mixed level of cultural competency across the profession. So again, you had some people that were really good at helping survivors go through that process of progressive disclosure and prepare them for the hearing. And you also had some adjudicators that were really fantastic at providing a great, safe place for survivors to share oftentimes their most horrific personal memories. Conversely, you had some people that were not good at that. And again, forced disclosure too fast, asked people inappropriate questions, said racist, ill-informed, ignorant things to Indigenous peoples that were both, were all of the things that I've just mentioned and or gendered. So unfortunately, we heard many survivors have some very, very difficult experiences going through that process. And to give you just a little insight into what we've heard from survivors, I think about one of my friends who went through the process, and he said at the outset, and I'm sure you've seen this in some of your professional work, at the outset when he began to try to disclose what had happened to him as a child in the residential schools, when the conversation became about the abuse or the physical violence, he did not have the ability, he had not reached the point in himself yet that he could even say yes to the fact that it had occurred. All he could do is crinkle his nose. So if the question was, friend, had you been sexually assaulted in the school? He literally did not have the strength yet to actually utter the words. So he could just sort of affirm it with this little facial gesture. And that is an example of where, working with through trauma-informed lenses and in highly sensitive ways really is an essential skill for people that are working with victims. And it's not an optional skill set that you can have. It's a necessary skill set. The other parts of the process that I think we saw too, and we, again, hearing from survivors where it was difficult, is the nature of the questions that were set up, and what we heard was that it did require a relatively invasive amount and a relatively invasive level of questioning. So again, when well executed, it could be done kindly and gently. But when less well executed, it was very abrupt and painful for the survivors, because the IAP process was based on like more or less a threefold test. The severity of the incident or incidents, the level of harm associated with the incidents, and then any aggravating factors associated with that. And I think it's really important for us to take a step back and really ask ourselves collectively, is the severity of the incident the important part, or is the harm the important part? And I would argue that the disclosure that was required to fully document the severity of the incident or the incidents was probably less necessary than the focus on the harm. Because I'm sure, again, as you've seen in your professional practice, that, you know, there is a correlation. There's no real correlation. There's a whole bunch of contextual factors related to how harmful an event or events can be. So you could have somebody, for example, that went through terrible things, but had a bunch of factors in their lives that resulted in less harm, because they either had increased supports or increased people, or, you know, maybe a helping hand along the way that helped them navigate the process. On the other hand, you had people that had sort of lower levels of harm, lower levels of severity, but extraordinary impact on harm because of a whole bunch of other contextual factors that were happening in their life. So I think, you know, we probably could have made a kinder, gentler process for survivors, and certainly survivors that we've talked to have really asked for that. Like, why did you need to know exactly what happened? Like, wasn't it enough to just tell you how I've been harmed and how my life has been literally destroyed often as a result of this? Lastly, I think we have to remember too that of the two processes, survivors were forced to go through the IAP process in order to receive financial compensation. There was no compensation going through the TRC route at all. It was kind of public good, truth sharing were the primary motivators. But certainly at the outset of the TRC, we ran into a lot of barriers, a lot of resistance from communities because of all of these factors that we heard with the IAP process combined to actually prevent many survivors from speaking to the TRC. They said, man, that was such a brutal process that I went through. I don't ever want to talk about my experiences again. I just want to like leave that behind. I'm done talking with this, because at first I had to talk to the form filler, then I had to talk to the lawyer, and then I had to talk to this, and then I had to talk to that. I'm done. So to that extent, it actually precluded people having conversations with the TRC, which is, I think, an issue that we're still trying to address. So one last point that I want to just share with you about what we've heard again, and I was literally just having a conversation with a member of our governing circle this morning about it, and a survivor, is that one thing that happened in the IAP process, not that frequently, but it did occur, where these incidents where a zero award was given, so no compensation whatsoever was given. So we have to take a step back and think about that with different hats on. I mean, one, for sure, I mean, there's some part of us that says, you know, from an administrative perspective, that, and from a justice perspective, that you don't want to be awarding compensation for a claim that's not legitimate. But the inverse of that is also that, say, for example, the person, through whatever reason, wasn't able to properly articulate themselves, or that the information that they disclosed was somehow deemed not as credible as it could be because of their own experiences with trauma, or perhaps with addictions, or perhaps with mistrust, or perhaps with a whole combination of those things, or perhaps a series of health factors. And then the person gets through the end of this and you know, reveals the most painful elements of their life, and then turns around at the end and is given literally $0, and the decision says, you're given $0, we don't believe you. You know, from the people that I've talked to, that zero award, those zero awards were very damaging for people, and really devastated many people that were struggling, and were harmful and created further harm. And I don't actually know exactly what the answer is, but I think we can certainly take a step back and say, you know, were the tests that we utilized in this process necessary? Were they overly rigorous? Recognizing that, you know, the invasiveness and the extent of some of the questions that were asked did put survivors in a vulnerable position yet again. So all of this has bearing because you may or may not have been noticing in the news over the last number of years that the Truth and Reconciliation Commission and the National Center for Truth and Reconciliation have been engaged in this long ongoing court process regarding what will happen to the records that were generated by this IAP process. And it's been a very, very contentious, it's been very complicated. This case has gone all the way to the Supreme Court of Canada and back down. We're in court right now. There's currently a case in front of the Court of Appeals in Ontario, all related to what happens with all the records that were generated by this process. And I want to give you insight into what the TRC and the NCTR's perspectives have been on the records related to this process in terms of justice, in terms of healing, and in terms of understanding who we are as a nation. The record that is contained within the IAP process is the best record of the worst abuse that was inflicted historically, because the IAP process, because it did have that graphic investigation, and because it was the mechanism that survivors had to go through in order to receive compensation, documents the history of residential schools in a way that even the TRC's statements do not. Secondly, the record of the IAP process also contains the record of whether or not justice in the grand scheme of things was truly served and truly administered by us as a country, whether or not we collectively fulfilled our obligations. And right now, the survivors' application form, the transcript of their hearing, the recording of the hearing, and the adjudicator's decision that was rendered are all slated to be destroyed in 2027, unless an individual survivor opts into the preservation of that material. And there's very, very good reasons. There's super good, legitimate reasons why a consent-based process is necessary and is legitimate and is appropriate. But there's challenges associated with the fact that survivors were not provided notice about this early enough, that many have passed away. And the corresponding effect is that, you know, there's no ability to review the administration of justice in this process. All of those decisions made by the adjudicators operating on all of our behalfs in rendering compensation on behalf of all of us as Canadian citizens will not ever bear any degree of scrutiny as it sits right now, except for very limited examples. And we've, again, seen good examples of fantastic work, and unfortunately, like every process, we've seen examples of things that are really regrettable and very unfortunate and should be learned from. More recently, the country, Canada, even the courts have taken yet another step towards the destruction of information. And not only are we destroying survivor information on this, but we've now taken this to the point that we're destroying all statistical information that has been generated from this process as well. And that was a case that was recently in front of the lower courts in Ontario, and is the one that the NCTR has now appealed. And we have decided, the courts have decided, that even statistical information on how many claims, for example, were, you know, how many claims by school or average processing time of a hearing should not be a matter of public record, even though there's no personal information in any of that information, in any of those statistical reports. This is very concerning for the National Center and for many of the survivors that we work with, and it's very troubling from a historical perspective, because right now, honestly, as a country, we know an incredible amount about what happened inside of the residential schools. We know an incredible amount about the specific nature of abuse that happened at many residential schools. and we have a great deal of information on the patterns and severity of harm and level. And by 2027, we will have destroyed the vast majority of that information, and we will actually know less in the year 2028 holistically than we know right now. We will know less about the residential schools in detail than we have the potential to know right now. And this has always been kind of at the crux of the matter of our overall efforts of truth and reconciliation. What do we need to know as Canadians? What information is absolutely essential for us to protect and preserve and to transmit to future generations in accordance with the rights, for example, articulated in the UN Declaration on the Rights of Indigenous Peoples? What information do future generations need to have so that we don't repeat these terrible mistakes of the past? And to give you insight in terms of how Indigenous justice and how Indigenous peoples are treated in this country, one of the most troubling elements of the decision that was issued by the lower court said that, paraphrasing, and just as the history of the Holocaust will not be made better understood by knowing which was worse, Auschwitz or Treblinka, I fail to see how knowing which residential school was the worst or which residential school had the highest number of claims will assist in the process of reconciliation. Now, I have to tell you that we've checked that quote with the American Holocaust Museum, with top genocide scholars from around the world, and that is completely, it's a completely non-factual statement. The details matter, and the details actually are really important for healing. So we're still faced in this time that we live in with a huge desire to not face the truth. We're not comfortable with the truth. The truth is really scary for this country, and the accountability associated with the truth, I think, is something that the country as a whole is very uncomfortable with. And for justice to be served holistically, accountability has to be a big part of that. The country, Canadians, processes, all have to be held accountable. And we have to continue to strive for better public service, better process, better treatment of victims of colonial genocide and abuse. And there's a lot that we can and ought to learn from these processes, and certainly we are learning some of the lessons. But it has been a significant and deep concern of the NCTR and the TRC that we still, in the name of survivors, are willing to destroy so much information when we haven't even gotten out of the gates. We're just reaching the point now where the majority of Canadians have actually heard about residential schools, and we haven't even really begun to unpack just how deeply and significantly this has affected communities, nations, individuals, our society as a whole. So there's a ton more that we can talk about, but I think I'll leave it there, and I'll open it up for questions, and really look forward to hearing your questions, and please feel free to ask me anything that you wish about this or other contemporary issues that are in front of the news, other issues related to the TRC's calls to action. I'm most willing to talk about anything. I hope this has been helpful, and yeah, thanks for listening to me.
Ry, allow me to just give a brief thank you, because I will give a longer thank you at the conclusion of the Q&A, but your remarks are certainly timely and insightful and reflect the depth of your experience with the TRC and the National Center's experiences. So I thank you for that. I have a personal experience to relate. I think I related to you when we first spoke 5 or 6 months ago, and I'll relate that in a minute. And there are some in-depth questions here, but there's a cluster of questions about the IAP records being destroyed, which I'll ask you to comment on first. So Why were they destroyed, or why are they going to be destroyed? You said, for good reason, and if you could elaborate on that a little bit. I might ask, what percentage of these records stand to be lost? And of course, one observation that the government's plan to destroy the records does not fit well with the commitment to reconciliation. What can the public do to support this fight to preserve these records?
Yeah, thank you for those questions. And I'm glad that there's interest in exploring this and better understanding this. This is a really, really complicated case. And the Supreme Court case, or the case that ultimately ended up at the Supreme Court, kind of hinged upon a couple of major arguments. So first of all, to give you a sense of who was involved in the case, when the main body of records destruction question went up to the Supreme Court, amazingly, Canada and the NCTR, the Coalition for Truth, which was an intervener, comprised largely of intergenerational survivors, and the Access to Information Commissioner, as an intervener, were on the side of preservation. And at that point, Canada's arguments actually were focused on principles embodied in international human rights principles that say that when the state has committed mass human rights violations, the state has a corresponding responsibility and duty to protect the record of those human rights violations. And those are called the Joinet-Orlichter principles out of the United Nations. And this has largely informed all human rights archiving and social memory principles on a global basis for about the last 15 years. The subtext of the argument, though, on Canada's side of things was also that, well, these are Canada's records and that these should be archived appropriately at the Library and Archives Canada, and that there was various allusions to that made in the forms provided to survivors, wherein they were informed that the Privacy Act would prevail and that only the Librarian and Archivist of Canada could destroy the records. And they also did rightfully say that the Librarian and Archivist of Canada, by statute, by mandate, has a direct responsibility to determine which records are of enduring historical value for the country. And that concept of enduring historical value is something that, archives wrestle with every single day, wherein there's records that are destroyed and there's records that are kept. And we all do this very naturally. We keep photographs and we delete some photographs. We keep old love letters sometimes and we delete other ones and burn them. We hold on to things so that we can revisit them and pass them forward. And that's what the concept of enduring historical value is. On the other side of things, it was a bit of a harder battle. You had independent counsel purportedly representing survivors. You had the IAP Secretariat fighting tooth and nail against the preservation of these records because they felt it was a fundamental violation of the confidentiality of the process. You had AFN and ITK being concerned about the Canada being party to this, and also worried about the potential for further harm down the road if this information was ever to be disclosed. You also had the Catholic entities launching a significant attack on the idea of retaining this information, because their arguments were largely and combined there was about 28 Catholic entities that were, if memory serves me correct, aligned here, saying that whoa, we bargained for a confidential process, and if this information gets out, that's a confidential process. So it was a complex case, and then a large part of the case focused on probably 2 or 3 main questions. So what was agreed to at the time the settlement agreement was signed. And this is being interpreted through the lens of contract law, essentially, like what was the deal that was struck and how do we uphold and maintain that contract? Because a contract is a contract. The challenge with that, though, is that the settlement agreement is more than a contract. And what the court generally wrestled with, and a lot of the arguments wrestled with, was that, well, this is like, it's kind of also analogous to a treaty. And there's this public law element to this, wherein there's these big fundamental notions of justice and healing and transformation and you know, kind of honor of the crown that come into these conversations. So there was an active conversation there. I think the other part of the dialogue focused on what does confidentiality actually mean? So does confidentiality mean deleting this stuff and ensuring confidentiality that way? Or does confidentiality mean burying these records in a concrete vault for 75 years and then very cautiously redacting the information? Does it simply mean redacting the information right now? Because from the TRC or the NCTR's perspective, the actual names weren't so important, and we felt that there was many ways to redact and clean up the information to protect survivors, and because we're also in the business of protecting survivors. But of course, you had other parties stand up and say, there's absolutely no way that you could redact these records without revealing personal information. Lastly, I think the Supreme Court certainly was challenged with the notion of, well, which way do you err, right? So there's no perfect way to obtain consent here, because on the one hand, you aren't going to be able to reach out to people. You're not going to be able to find them. And many people have passed on. Like, they're just literally unreachable because they're not on this earth anymore. So what about their rights? And then, so do you go out and ask the people that are still alive if they want their records preserved, which is going to result in a few, or do you protect the whole and then ask the people that are alive whether or not they want to opt out of the process somehow? And it's like opt-in, opt-out consent. And we all know that opt-in consent is the higher test and the more standard test that you would usually apply. But in the context of historical information on this case, I mean, opt-out was certainly a way of dealing with the immediacy and the concerns of people that are alive right now. Lastly, you know, the case didn't really get into I think a rich discussion, or a rich enough discussion, on individual versus collective rights. The major thrust is on the question of enduring historical value is what do future generations deserve to know? What right do future generations have to this information on a collective basis? And then how do we balance that with the very real, very legitimate individual rights of survivors to privacy and to confidentiality? And how do we balance that collective versus the individual right? So ultimately, I would say that the court adopted or undertook what I would generally call as a pretty Western approach, wherein individualism prevailed. The privacy of individual survivors was placed the most heavy emphasis on. The court was unable or unwilling to differentiate between different elements of the records, so they chose not to look at the decisions as being separate from the hearing transcripts, for example. And I think, sadly, from my perspective too, okay, so even if we end up with this decision, and even if we were to have this enhanced notice program, which was the mechanism by which survivors would be informed of their right to preserve their records, the courts did not allocate or would not support any funding for community engagement sessions. So they funded some posters, they funded some helplines, they funded 8 train the trainer sessions. Canada, of course, objecting to this the entire way along because Canada had to pay for this. But there was no robust notice program really provided, other than some media and some dissemination through some limited television commercials, so on and so forth. So we've never really had the ability to sit down with survivors and have a full in-depth conversation with them. And again, when it comes down to working with survivors on something like this, and working with really Indigenous peoples in general, the right question that many Indigenous peoples have is, how are we going to get harmed again? How is this process going to come back and blow back on us again? How are we going to see this hurt us once again? Because our country is just full of broken promises and lies and deceit and a fundamental lack of trust, you know? So survivors rightly are suspicious, and they have every right to be. And the challenge that we've had the entire way along is that we, from the center's perspective, wanted to sit down and really have a good chat and help inform people. But even there, what we encountered was that there was really a strong desire to not see those community engagement processes happen, and to actually lessen the overall conversation on this information being protected. So I sincerely believe, and I feel very strongly, that this is one of the most significant cases in the history of the country related to Canadian history and the destruction of information. And I feel that it is abysmal, or an outrage, that more Canadians don't know about this, that all of this has happened kind of so hurriedly behind the closed doors of the courts, and that both survivors and Canadians have not somehow been fully engaged in this conversation. Because, all of the arguments related to protection of personal information are super legitimate, and all of the arguments around confidentiality are really, really important. But this is really big stuff, and this is Canadian history, and this is the best record of the genocide. And I just think that it's very concerning that we haven't had this big, broad conversation. And of course, now we got this Supreme Court decision too, which are kind of anchored in stone. So we are running headlong into the ongoing destruction of information. We're continuing to see the court signal that they want this information destroyed. And 2027 is going to come around very fast. And I think, the question that I've always asked myself is, what does that day look like? And what happens on that day? Does somebody just hit delete in the basement of a government office somewhere? Or what actually happens, and who's there and who's present for that? So hopefully that answers some of the question. I know that was kind of a long answer, but it's a very complicated case, and it's very contentious. People have very strong feelings with it. I think from my perspective, it was really difficult because there was not universal consensus even amongst the Indigenous community, and sometimes you saw survivors speaking out very strongly about the need to preserve this information, and other survivors saying, keep your hands off of this. This is like, how dare you? And that's the unfortunate consequence of this element of the settlement agreement really not being better executed or more well thought out at the beginning. And we're living with the ramifications and repercussions of that, and we're all stuck with a far less than ideal circumstance, and I think still a far less than ideal outcome from my perspective and the perspective of the NCTR, and I know the TRC as well.
Thank you, Ry. That was very comprehensive, and I believe it answers a number of the questions. I am actually getting more questions that I will have a chance to pose, and I will do my best to lump a few of them together. Just for the benefit of our participants, we will go as late as 1:15. I will end it at 1:15 as in accordance with our scheduled time. And I'll do my best to put those questions together. I think perhaps I will just ask you a little bit about your thoughts regarding the future of the National Center for Truth and Reconciliation, your hopes and aspirations. I'm sure you know, when you embarked on this role, you didn't intend to spend 10 years in court. fighting for what is a very important cause. And I really appreciate you bringing the importance of that cause to our attention. And we'll certainly be, looking to see what contribution we can make. But what remain your hopes and dreams for the center? I suppose it dovetails into one question posed by a member, and that is, the National Center is but one of many things that were to be undertaken by the government in the aftermath of the TRC. How confident are you that we as Canadians, as a society, are actually moving forward in the broader context on that as well? So your hopes and dreams for the center, and of course the broader question of the TRC recommendations, and where do we sit 5 years out?
Thanks, Paul. So in order to understand the National Center for Truth and Reconciliation mission and mandate, we again have to situate it in that international context as being a transitional justice mechanism. And in understanding it that way, we need to understand it as being a very important response to that international requirement to preserve the record of genocide, preserve the record of human rights violations, and also to place that under the authority or control of the people that have been harmed, right? So what we have done in the country through the TRC's processes was go out and collect records that were under government or non-Indigenous control and bring those records under Indigenous control. Now, we still have to operate within, I guess, a colonial framework in that we have access and privacy legislation that we take very seriously, and the protection of personal information is something that is bread and butter central work for us. But the notion of bringing the information from external bodies together in order then to be repackaged, redisseminated, or disseminated out to communities is a very, very important part. And that's an overall effort of historical repatriation, resurgence, and assertion of inherent rights, I think, by Indigenous peoples to have access to this information. And we have to remember that this collection stands on guard permanently against efforts to deny that this ever happened, and that what occurred in Canada was in fact as severe as it actually is and has been. So the NCTR as an institution is intended to be around forever in this country, and by forever we mean forever. It has a responsibility to forever preserve this material. And I think what is exciting is through the TRC, we're seeing the addition of yet another major Canadian institution in its nascent form, arising and developing. 50 years from now, we'll look back and we'll say, wow, isn't this great? Like we've had this institution that's got a 50-year history, and we're just kind of at the birthing stage and the teething phase of the organization right now. And it's got a very long and complex and dynamic road ahead of it. But the fact that it exists, I think, is actually very, very important, and it hasn't actually been easy to establish it. I will tell you that from firsthand experience. We've had many attempts many attacks on the center, I think it's actually correct to say, because I think the truth is powerful, and this country is still not in a truth-telling mode. So we've had to endure a lot, and I think there's a corresponding recognition that this collection has a great ability to achieve many things. And it's too bad when we see people trying to appropriate the center and either make it about themselves or make it about, other goals and ambitions other than what the mandate or the goals and objectives of the TRC set out to achieve. So, it's the NCTR was also born into a very dynamic time in Canadian history too, which I think is real cause for celebration, because we look at other post-TRC times. For example, South Africa, there was not the preservation of material at the end of the South African TRC, and that's been a real challenge, wherein a lot of the information that was gathered has been now lost and is not there to be of benefit to Indigenous, well, in that case, communities, researchers, and others looking to better understand. Now, so the NCTR exists, it's here, it's got a long road to hoe in front of it. It will continue to walk its path. I mean, it's in pretty good shape right now in that we've got good, solid funding, but there's a lot more work to be done in terms of further stabilizing that, further expanding the mandate, building a permanent home for the NCTR is very much part of the goal and ambition as well. Now, more broadly, how's Canada doing on the calls to action? Well, so you've got the federal government, Canada, and then you've got the country more broadly is how are we as Canadians doing on the calls to action? And, you know, how's Canada as a government doing? Okay. It's doing okay. In some areas, has achieved success. In other areas, it has dropped the ball. You know, I certainly had hoped, and many of us had hoped that, for example, we would be much further along on the establishment of the National Council on Reconciliation. The National Council on Reconciliation is the sister agency to the NCTR that really addresses the question of where are we in terms of status of the call implementation, monitoring whether or not the gaps that exist between Indigenous peoples are widening or closing, and then really establishing clear multi-year plans on what the country needs to do, including issuing an annual report on the state of reconciliation in this country. It's a very important accountability mechanism wherein all levels of government, businesses, churches, heritage sector, so on and so forth, are meant to be held to account to whether or not they're actually upholding their calls to action. And we're 5 years out and the council does not exist yet. There's been some steps and there's been some funding and there's been an interim council and there's been a report that's been released, but it's far from stable and far from anchored and does not have anywhere near the profile or strength that it needs to succeed. So that's a major gap in implementation. Conversely, I mean, we've got Indigenous languages legislation now. We've got national child welfare legislation. I understand that efforts are still being made to introduce legislation on the UN Declaration on the Rights of Indigenous Peoples. Canada dropped its objector status or its reservations on the UN Declaration on the Rights of Indigenous Peoples, which is important. That's an important symbolic step, and now the rubber has to hit the road. You know, there's been a wholesale substantive effort, I would say, across all educational institutions and the K-12 system, and even within the Canada School of Public Service, to enrich the quality and level of education being provided to people. And I think on the education front, that's one of the areas that we're doing best as a society. But we're really not doing good on the accountability and transparency piece yet. And that's evidenced by the IAP case that we're talking about. That's evidenced by the National Council. We're just not that interested in truth on an ongoing basis because the truth is uncomfortable. It makes agencies, organizations, nations vulnerable. But that vulnerability is absolutely essential in overcoming this terrible legacy that we've got.
Thank you, Ry. For the record, I will just let you know that I'm seeing a diversity of opinion being expressed in the Q&A and the comment section regarding the necessity of, retaining the IAP records. And, there's quite a number of expressions of dismay that the records will be destroyed, or how can we assist in retaining these records. There are others who have commented that, the TRC report itself should be sufficient, or that there are counter arguments that are perhaps more compelling, many of which you have recognized, and you have also recognized different manners in which these records could be retained, locked away, sealed in a concrete box, as you suggested. There won't be time for you to comment further on that, but I just wanted to let the membership know, or the attendees know, that I'm seeing these comments. What I will turn to, though, is I think it is often unfortunate that it takes events in the United States or around the world to raise our consciousness about particular issues. And certainly the Black Lives Matters incidents and movement in the United States has brought racism and questions of Indigenous treatment to the fore here in Canada. There's been an interesting debate amongst our sister organizations about whether we should express support for the Black Lives Matter or whether we should broaden it to talk about all communities and, you know, black and brown and people of color. Just curious about your own thoughts about what has transpired in the States and the impact it's having on the discussion here, whether we should, you know, be adopting some of the US perspectives or whether we should be making this our own conversation.
Yeah. Racism and discrimination and oppression, while they all share a common root, which is kind of the exercise of power, have been exercised differently against different groups. So the experience of Black people in the United States is different than the experience of Indigenous peoples. And while there's similarities, and it's important to recognize those similarities, it's also very important to recognize the differences. And we talk about this in Canada, even here, in terms of a distinctions-based approach in recognizing that First Nations are different than Métis. Métis are different than Inuit. Inuit are different than First Nations. And even amongst First Nations, while there's a commonality of experience associated with the Indian Act, and there's still a great deal of difference of experience within the system of history of colonization and oppression. So the fact that we're recognizing Black Matters and affirming that Black Lives Matter is absolutely what we should be doing, because Black Lives matter, no question. And we have to understand the very specific way in which Black lives have not mattered to states and nations, and how Black lives continue to be devalued and harmed directly in very specific ways. And we have to deal with those elements of racism and oppression and discrimination in a very specific and conscious way. Indigenous peoples are also the victim of many of the similar types of violent acts and racist acts directed against them. And we have a very long history of that in this country that, you know, I alluded to in our efforts to address that. And we have to recognize that, for example, the United Nations Declaration on the Rights of Indigenous Peoples is a human rights mechanism. That's fundamentally what it's all about. It is a mechanism that upholds and protects the human rights of Indigenous peoples. But why do we need a specific UN Declaration on the Rights of Indigenous Peoples to protect their human rights? Because the human rights of Indigenous peoples have been attacked, have been violated in very specific ways. And unfortunately, where we need to start the conversation with Indigenous rights is that, yes, Indigenous rights exist, human rights exist, and Indigenous peoples are human beings. That's how the level at which we're still trying to unpack the conversation. Because if we look to Canada, for example, we see vastly different human rights standards being employed and enjoyed by Indigenous peoples. Like, you know, Indigenous peoples do not enjoy the same level and protection of their human rights that non-Indigenous peoples do. And that finds its root in systemic discrimination and racism and a whole bunch of other devaluing that has happened of Indigenous life. So for certain, I mean, like, we have a history in this country. We need to understand our history. We need to understand how oppression and genocide and racism operates in the context of Canada. It's all alive and well here. It's all a scourge. It all has to be challenged. We have to adopt a distinctions-based approach, and it's perfectly fine to do that. And we have to recognize that what is happening globally is that the voices of historically marginalized people are important, that they need to be listened to, that they have something really, really important to say, and that we should be collectively celebrating this huge upsurge in the amount of space that we're creating for people of color, Indigenous peoples, historically marginalized peoples. The more space we can create for those voices inside of our organizations, inside policymaking, inside governance, inside all systems, the better. And at the same time, we have to recognize that we have a lot of work to do as organizations to actually truly create safe places for all of those groups to succeed and thrive. And that's how systemic racism works and how systemic discrimination works, is that if you're one of those Indigenous peoples or people of color trying to make the change from within, that can be a darn tough place to be because of the way allyship and systemic barriers operate. So it's really important what's happening globally. And so much about what's happening in this country right now, be it not small examples, big examples, like dropping the name Queen Charlotte Islands and adopting the name Haida Gwaii, are all examples of conversations that are happening around the world on how best to decolonize and how best to accurately reflect the lands and the histories that we are living in. And when we talk about history, none of this stuff is about erasing history. So when you see statues getting pulled down or names being removed from buildings, we're not erasing history, we're repairing history. We're actually bringing in the multiple perspectives that are necessary in order to understand who we are and where we came from. So this is all repair and healing work rather than maintaining ongoing broken systems.
Thank you, Ry. That was very helpful. And, before I move to close, I'll just remind our attendees that we will do our best to preserve the questions that have been posed and perhaps not answered, and we'll try to get some answers out to you. There will be follow-up from Sandra. And also, if you choose to express your appreciation for Ry's time with us today, I am certain that there is an appropriate cause or charity in your own area, or you can utilize the Boyle Street Center, which was Ry's suggestion for something locally here in Alberta. Sandra, again, will send those details out. I guess my last question before we close to you, Ry, is just, what else can we do as individuals or as organizations to participate in the reconciliation process? We did have one attendee who asked, is there a difference between conciliation and reconciliation? You might comment on that as well. But, what can we do that is meaningful, beyond just land acknowledgements, some of which, feel like just words on a piece of paper at times. People are actually looking for something that they can do that demonstrates reconciliation.
Yeah. I mean, there's so much that we can all do, and something that we can always do is work on our own self-improvement. And it sounds kind of weird that this is the solution to historic oppression and injustice, but self-awareness, understanding what we know and where we learned it from, and more importantly, understanding what we don't know, is super important. So when I talk about self-awareness, I think what I would ask you to do is take a look inside yourself and imagine that you have a lovely bookshelf inside of yourself. You have a lovely library of your life experience and information that you've learned and gained in your life. And then I'll ask you to look at the section on Indigenous peoples and ask yourself how many books are on that element of the shelf. And then I'll ask you to look at who wrote those books and were they written by Indigenous people, and how expansive that collection of your personal library is. And a lot of Canadians don't have all that much information on their personal bookshelf there. They don't have a lot of information on that part of their library. Some do, right? But some also might have a lot of information on Indigenous peoples that has never involved any meaningful dialogue or discussion with Indigenous peoples. It's written on rather than with or by. So really pay attention to the author. And what I would then encourage you to do is to really go out and seek out the with and by authors and fill up that bookshelf as much as you possibly can through every way that is possible. Experiential learning, dialogue, film, music, experience by attending gatherings, publications, so on and so forth. And just be careful with your opinions too. Be conscious of your opinions, I guess. If you don't have a lot of stuff on your shelf, be really conscious about how strong your opinions may or may not be on certain issues, because there's a lot we don't understand yet. And I'll be the first to say that, I mean, I've done this work personally, professionally, intensely, and I mean, I still have so much to learn and so much to know. It is a lifetime's worth of learning about Indigenous histories and peoples in this country, and it is a beautiful journey. It's a beautiful journey, and it's one that I guarantee you, if you embark, you will be directly enriched by it. I guarantee that. You will not be harmed by it. You will not be made into a worse person. You'll be made into a better person. And you know, lastly from there, just again, in your professional interactions, be really conscious about voice, be really cautious about position. Recognize that reconciliation is not about hugging it out and smiling at one another in the absence of rights. It's about reconstituting Indigenous people's inherent rights to be Indigenous. Whether or not that's something that looks familiar to you or to this country or not, Indigenous peoples have a right to be Indigenous in all sectors and levels of society. So recognize that this is a rights-based journey that we're on, and that the most important way that we can conduct our work is walking alongside and with Indigenous peoples in the exercise of their rights. And when you see Indigenous rights being violated or abrogated or impaired, that you have a corresponding duty to stand up and speak out against that. Just as I would expect you to stand up and speak out when you see human rights being violated. You know.
Thank you, Ry. That answer actually really resonates for me. You know, not 2 hours ago, I got a text message from my daughter in Ottawa saying that she'd overheard a racist comment and she was embarrassed that she didn't speak up, and that she was going to be better prepared to speak up next time. You know, that notion of the most important thing we can do is learn and understand and then act. I think that's hugely important. My personal journey, you know, I've had employees from Rwanda that have spoken to the Truth and Reconciliation and the process of healing in that country. I've had dinner with Senator Dallaire on the same subject. You know, if I look back 40 years, I know I share with some embarrassment, and I know I shared this with you a number of months ago, that I attended high school in northwestern Ontario, Sioux Lookout specifically, and it's with some embarrassment that I share that, you know, we had 450 students, but 80% of them were in grade 9 and 10. They were Indigenous, and even though I was, you know, executive student council, I knew nothing about them. They came, they left, they were quiet. I was living 20 kilometers away from a residential school where they resided, and I had no idea of their circumstances, the fact that they were denied many aspects of their language and culture, that they only spent summers with their families. And you know, I look back at that and I think, how could I not have known that? And as you said, we don't know what we don't know. And this has been a journey. The TRC has been a journey for many of us. The Commission on Missing and Murdered Indigenous Women was educational and a journey of learning. And I thank you for sharing your experiences and your hopes and dreams for these communities with us today. Folks are not able to applaud. I do encourage you to type in your thanks and expressions of appreciation to Ry. Make a donation if you so wish. And we will do our best to preserve these records and correspond with you more about getting some more questions that weren't answered today. But my sincere thanks to you, Ry. My sincere thanks to all of our attendees today. And I wish you Godspeed on your personal journey.
That's wonderful. And I really want to thank you all as well. And my final parting thought is for all of you that are going to be wrestling with this great question of destruction about these records, know fully that I have absolutely wrestled with all of those questions myself deeply, personally, and with many, many people helping me navigate these questions. And I think, my parting thought there is a diversity of opinion is healthy and good on this. We should be discussing this, because I think the greatest shame is that we haven't discussed it enough, and that it just all seemed to happen so darn quick. And I think the consequences of our actions will still, we've not even begun to realize what those are. So I really want to thank you, and you know, to the organizers, it's a wonderful opportunity to speak with you all. Keep up the good work. You're doing really important work, and you know, thank you very much.
My thanks again, Ry. And we're gonna keep this these panels open, but people will log off now, and we're just going to make sure that we can preserve all these questions and chats before we shut the seminar down. I look forward to talking to you in the very near future.
Thank you.